Good morning, welcome to UCC Legal Work. Today we will answer some questions about patents and their role in international arbitration. We will start by explaining that it is a patent.
A patent is right of exclusivity that is granted on an invention. In general, a patent authorizes its holder to decide whether the invention can be used by third parties and if so, how.
Do patents have validity worldwide?
Patents are territorial rights. Generally, the corresponding rights of the exclusivity are only valid in the country or region where the application form has been filled and the patent has been granted, according to the regulations of the country or region.
How long does the term of a patent last?
Protection is granted for a limited period, which usually corresponds to 20 years, beginning on the date in which the application form has been filled.
Are there any international patent-related rules and treaties?
The treaties that WIPO manages, along with national and regional standards, constitute the international legal framework for patents. Paris Convention, Patent Cooperation Treaty (PCT), Strasbourg Agreement on the International Patent Classification, Patent Law Treaty, Treaty of Budapest, Standing Committee (SCP). In the Standing Committee on Patent Law (SCP), WIPO works with its member states and observers to develop balanced international legal frameworks for patent standards and policies.
Is there an international patent agency?
Yes, the World Intellectual Property Organization, WIPO, is a specialized agency of the United Nations system created in 1967 with the signing of the Stockholm Convention. WIPO is dedicated to promoting the use and protection of works of the human intellect. Today, WIPO manages 26 treaties, for two of them along with other international organizations, and through its member states and its secretariat carries out a comprehensive and varied program of work for the following purposes: to harmonize national laws and procedures in the field of intellectual property, to provide processing services for international applications of industrial property rights, to promote the exchange of intellectual property information, to provide legal and technical assistance to the states that request it, to facilitate the settlement of intellectual property disputes in the private sector, and to promote the use of information and internet technologies as instruments for the SRH, access and use of valuable information in the field of intellectual property. Does it mean that it works as an extrajudicial dispute settlement?
Yes, the WIPO Arbitration and Mediation Center is a neutral, non-profit international dispute resolution provider that provides fast, cost-effective options for dispute resolution without recourse to the judicial route.
Why resort to arbitration in disputes relating to intellectual property?
Arbitration as a private and confidential procedure is used increasingly to resolve disputes related to intellectual property rights, particularly when the parties are from different jurisdictions.
How to submit a request for arbitration from WIPO?
The request for arbitration must be based on the WIPO arbitration rules and on the information asked. 1. An application for dispute must be submitted to arbitration. 2. The names and delayed communication data of the parties and their representatives. 3. A copy of the arbitration agreement and inapplicable and independent clause relating to applicable law. 4. A brief description of the nature and circumstances of the controversy. 5. An indication of the claim subject to the application and to the extent possible an indication of the amount demanded. 6. Any requests or observation relating to the appointment on the tribunal, including to the number of arbitrators and the qualification thereof. The Senate recommends that the request for arbitration be submitted on paper and be emailed. There shall be enough copies on paper for each arbitrator and for the Senate. The defendant and the plaintiff must pay the registration fee to the Senate. Upon receipt of the request for arbitration, the Senate shall direct to the parties a written acknowledgment of its reception and shall indicate the beginning date of the arbitration. Now we are going to see the main phases of the arbitration process of the OMPI, which is meant to be executed in a 9-month period.
They begin with the request for arbitration. After 30 days, the response to the request is received and the appointment of the arbitrators is made within 30 days. After this stage, the written statement of claim and its reply are prepared, for which 30 days will be available for each process, and the hearings will immediately begin. The hearings must not exceed a 3-month period and will end with the closing of the proceedings. Once this stage have been complete, the arbitral award is issued.
Well, we hope that you now have a better understanding of patents and of the process to present application for international arbitration as an alternative mechanism of conflict resolution. See you next time.